The question is that this bill be now read a second time. The member for Blair.
Thank you, Deputy Speaker. I am pleased to speak on the Migration Amendment Strengthening Employer Compliance Bill of 2023. Deputy Speaker, if ever there was an example and an issue which demonstrated the importance of the role of the trade union movement, it's this one. And I want to pay tribute to a number of trade unions who have been the forefront of advocating for this type of legislation and bringing to the public's attention the shocking and egregious exploitation of migrant workers. The SDA, the TWU, the AWU, UWU, the AMWU and other unions have been at the forefront of the campaign for better working conditions for migrant workers and urging the previous government to take action in relation to the egregious exploitation of those workers. When I was the Shadow Minister for Immigration and Border Protection, I visited circumstances and places of work and had forums in places like my hometown of Ipswich, where metal workers were being exploited, hospitality workers in Melbourne, farm workers in Bendigo. And I want to pay tribute to the member for Bendigo, who has been the forefront of the campaign on this issue for such a long time. This legislation is long overdue. 1,100 days in office, yet those opposite did nothing meaningful for migrant workers. Between the 7th of March 2019 and the 10th of April 2022, 1,100 days passed, during which the Morrison government did nothing meaningful for migrant workers. And why are those dates important? On the 7th of March 2019 was not only the Migrant Workers Task Force report released, but the government response was also released. The Morrison government responded glibly, without giving the report the respect it deserved, then failed to implement its recommendations. On the 10th of April 2022, it just happens to be the day the then Prime Minister, the member for Cook, paraded off down to the Governor-General, not giving himself another ministry, I might add, but to call the federal election. So it was 1,100 days passed with nothing meaningful done. Just to demonstrate the abject dithering and delay of the former government, do you know who tabled, Deputy Speaker, the government's response to the Migrant Workers Task Force? The former member for Higgins, Kelly O'Dwyer, a couple of members for Higgins ago. Not only did a whole parliamentary term go by when the Morrison government did nothing meaningful, but two members for Higgins came and went. And the irony is the current Labor member for Higgins has been in this place by way of a skill migration program, and as such, I know she recognises the struggles of migrant workers to make their way in Australia. Having arrived in Australia in 1984 with her parents from the UK via Zambia, the current member for Higgins' father qualified for skill migration to this country as an accountant. Dithering and delay, and that's why this legislation is absolutely important. The member for Moreton aptly gave the figures from the Grattan Institute and from other reports from Unions New South Wales of the shocking exploitation of migrant workers. And this shames this country. It shames Australia internationally when people who come to this country get exploited. Sexual exploitation, wage theft, workplace conditions that none of us would find acceptable. It shames our country, and it was ignored by the previous government. Now, there was so much in the area of migration that we needed to do, but I want to pay tribute to Professor Alan Fels and AO and Dr David Cousins AM, who wrote. They were the co-chairs of the Migrant Workers Task Force, and they put it best. Wage exploitation of temporary migrants offends our national values of fairness. It harms not only the employees involved, but also the businesses which do the right thing. It means that businesses who do the right thing by their workers get punished, and they themselves get exploited. So it's workers who work in their workplace get exploited, and the businesses who do the right thing get exploited, and it puts at risk the workers who work for good bosses, good employers, at risk as well. And the thing about this is that don't forget the temporary skill migration income threshold, the TSMIT, which was the basis on which someone had to come to this country and not be paid less than, of nearly $54,000, hadn't changed from 2013 onwards. So the previous government didn't change it. We got in, we've increased it to $70,000 per year. Now, the reason for that is that the previous government had a deliberate design feature. It was an aspect of their core belief to drive down wages. So, unintentionally, unwittingly, I think, they were sort of helping the exploitation, weirdly enough. I don't believe they genuinely meant it. I really don't. But by their policies, they were almost aiding and abetting inadvertently what was happening in the exploitation. And that's not good enough. I don't believe those opposite have those views, genuinely. I do not believe it. But their failure to take action meant that the exploitation continued, whether it was in Bendigo or in Melbourne or Ipswich, and that's what happened. It's simply not good enough. Now, I want to pay tribute, and I know that there were many stakeholders who came to the report for the Migrant Workers Task Force, the ACTU, the Chambers of Commerce and Industry, Recruitment and Consulting Services, the National Roundtable on Human Trafficking and Slavery, the National Farmers Federation, the Australian Industry Group. You know, it's a 140-page report. I've read it. It's a comprehensive report. The previous government did 3 pages of response, 3 pages straight away, barely acknowledging, tokenistic, patronising in many respects. More than 2 years of painstaking evidence gathering on the exploitation of vulnerable workers. I think Professor Fels and Dr Cousins had very great grounds to feel dismayed and disappointed. It's very clear there was systemic exploitation in our labour market. Very clear. And it was hiding in plain sight. There were many companies, and I won't name them all, but many companies that we Australians deal with each and every day who have attracted adverse media attention for the employment arrangements. Those are companies that people might go and get a coffee at or a donut at. They might be getting their petrol from them, and they're exploiting workers. Well-known brands throughout Australia, and it's simply not good enough. Now, we need to do everything we can to prevent the exploitation of workers through the entire value chain. Recently, another case came up before the Federal Court on behalf of 4 migrant workers, and the SDA, the Shop, Distributor and Allied Employees Association, alleged that a franchisee had failed to pay them for all the time they worked. They failed to pay overtime in correct penalty rates. They operated a cashback system. They misclassified workers. They denied them paid entitlement, and they breached pay slip and record-keeping requirements. And the back pay resulted in payments, for workers not being paid hundreds of thousands of dollars. And it totally, effectively, in the end, it totalled up to, when they did all the calculations, $1 million in underpayments. And they sought penalties against the franchisee and the franchisor for breaching the Fair Work Act. Now, that stuff is all too common. But we had the Retail Supply Chain Alliance, comprising the SDA and TWU and the AWU, making recommendations to the Senate inquiry, and there'll be many inquiries in this place, in this House and elsewhere as well. Not just the Fels and Cousins inquiry. The Senate inquiry recommended important changes as well. So that Senate inquiry that the Retail Supply Chain Alliance, consisting of the SDA, TWU and AWU, made a very good submission, can I just say, into the unlawful underpayment of employees' remuneration to ward off ongoing exploitation. And there were many recommendations about making sure a visa system that works, and we're taking action here. One of the most important things we did was to slash the visa backlog, processing times improving due to 500 extra workers, having a national labour hire regulatory scheme, other better licensing arrangements, more funding. So these are some of the things we've taken up. This bill in particular is very important because it makes it a criminal offence to coerce someone into breaching their work-related visa conditions. The key recommendation from Fels and Cousins. And why was it so difficult for the previous government to do that? There was no excuse. It's not like they had a huge legislative agenda that we were dealing with every single time we came to this place for 1,100 days. 2 members for Higgins. And they still couldn't bring themselves to bring it in. They could bring it into the chamber, but not debate it, not pass it. The Labor would have supported it. There's no doubt about it whatsoever, but they wouldn't do it. So we need to make sure that we do it, and this legislation is picking up those recommendations. The forms of exploitation for the task force were many, and I would commend people who might be listening to look at it. Unfair dismissal, unpaid training, working conditions that are unsafe, upfront payment or deposit for a job, pressure to work beyond the restrictions of a visa. So there were many, many things that were just egregious and appalling. So under this legislation, it will be an offence to use a worker's visa status or a future work-related visa requirement to coerce or unduly pressure a person into accepting an exploitative work arrangement. This was an election commitment we made to help remove barriers to stop exploited temporary migrant workers from speaking out and seeking support. We're keeping our word. We're delivering on outcomes for migrant workers and through them to improve wages and conditions for all workers, and that's why we increased the TISMIT. This bill includes further important measures such as where an employer has been convicted for underpaying migrant workers, that employer will be unable to employ migrant workers for a specified period of time, closing a loophole in our migration system. This prohibition is necessary to protect workers from employers who engage in serious, deliberate or repeated non-compliance with their obligations. And we're publishing information about this. That's important for transparency, that the workers actually know who are the good bosses and who are the bad bosses. Everyone working in this country is entitled to protection from exploitation, including those on temporary visas. And we're committed to making sure that wages and conditions are improved for everyone by stopping exploitation by unscrupulous employers. We're committed to the principles of natural justice or procedural fairness, decision-making based on factual evidence, a long-established approach to responsible government, which seems to have eluded those opposite when it came to this issue for most of the last decade. The bill provides that an employer can be declared prohibited. That is, the decision-maker must give the employer a written notice, and that notice must state the decision-maker proposes to make a declaration and provide the reasons for doing so. The notice must invite the employer to make a written submission setting out reasons why the decision should be made. Fairness, procedural fairness, natural justice. The employer will have the opportunity to set out extenuating circumstances which must be considered in decision-making. There's penalties to have a deterrent. They must be set at a level that actually deters people from offending. The bill does just that by increasing the penalties for unscrupulous employers misusing migration programs, and this reflects the significant damage that employers who've done the wrong thing can have on the public confidence in our migration system and our national prestige and honour. A key element of this bill is to repeal the offence currently set out in section 235 of the Migration Act 1958. That section makes it a criminal offence for a visa holder to work in breach of a work-related visa condition or for an unlawful non-citizen to work at all. This offence has undermined the ability of workers on temporary visas to have recourse to their rights under certain workplace laws such as workers' compensation laws, and we've removed that barrier to justice. Migrant workers should have the confidence to speak out and seek help without fear of visa cancellation, and the measures in this bill support those aims. Specifically, the commitment between the Department of Home Affairs and the Fair Work Ombudsman, known as the Assurance Protocol, will be reformed. The protocol encompasses that a worker who holds a temporary visa will not have their visa cancelled for breaching a work-related visa condition if certain criteria are met. Stakeholders have told the government that the protocol is too secretive to instil the necessary trust and confidence. They don't trust it because it's not transparent and it's not legislated. The bill will allow the government to make regulations and legislate the protections that are currently only available under government policy. This government will work alongside industry and community groups, unions, civil societies, lawyers, researchers and other experts to examine protections available to workers on temporary visas and encourage them to speak out when they face exploitation at work. This government recognises the important role of the Australian Border Force in compliance and enforcement. For those employers who choose to do the wrong thing, beware the ABF and the law will catch up with you. In the recent budget, this government increased funding for immigration compliance. So those who misbehave, those who do the wrong thing, those who exploit workers, will be penalised. The Albanese Labor government will continue to work together with the community and industry groups across the country towards eliminating exploitation of migrant workers. In turn, this will improve wages and conditions for all workers. Now, that's something that any Labor government can be proud of. It's something that every government in this country should always be proud of. Even a coalition government should learn their lessons from the last 9 years. I commend the bill to the House.